Hey, good morning, everyone. Taking family law. I thought I'd put up a brief video, or at least brief for me, on domestic violence, chapter 3 in your book. This is one of the reasons why I've chosen this book. And just as a quick aside, I know some of you have the 7th edition, some of you have the 6th edition. I have both. I have the physical 6th edition, but I have an electronic version for the 7th edition. The assignments I'm giving are the same whether in the 6th or 7th edition. It's just a matter of page or pagination, which page it'll be on. So if I give you questions 1, 3, and 7 on page 95 in your textbook, it might simply just be in a different page in your book if you're using the 7th edition or the 6th edition. Just end of chapter questions. And same with if I ask you to do a case analysis, it'll be the same case. It just might fall on a different page in your book. And if it doesn't, if for some reason your book doesn't have the case, I will certainly augment the assignment by putting a hyperlink to the actual case, because these are all real cases in your book. But chapter 3, and one of the reasons why I picked this book, and I liked it a lot, not only because the author's from Massachusetts, it's not really why I picked it at all because of that. But I picked it because they do a nice job on domestic violence. And whenever I taught this course previously, I always used to have to augment previous books regarding the whole issue of domestic violence and protective orders, because it's a big part of family law. It's a big part of criminal law, too. And we'll get to that in this little mini lecture. Why is it? Because so many relationships, and that's what family law is about relationships and the breaking down of relationships, not just marital relationships, but other relationships. And when they break down, they often break down, sadly, over domestic violence or threats of domestic violence. And we need to study this a little bit and talk about it, not just in terms of statistics and the sad fact that there's a lot of domestic violence out there, mostly um, on women by men, but not entirely. There are cases of children on their parents, parents on their children. There are women on women, men on men, but they all have to meet a certain standard in order to be applicable to what we call a 209A protective order. But it's rampant, it's significant, and it's interesting to study just on a psychological or sociological examination, but it's critical in law. You can't go out and become a paralegal and work in family law or an attorney um, or just a citizen and not know or have some knowledge about the impact of domestic violence and how it permeates the court system. Is huge. It's a big area. So the book does a really nice job of introducing domestic violence. And you have to remember most relationships, or a significant amount of relationships, when they dissolve and there's court action, may not actually be involved with a divorce. I believe it's over 50% of children are now born out of wedlock. So marriage is becoming less significant, but rights and obligations still flow between couples that have children and are breaking up. And one of the breakups might be about violence, about domestic violence. So we have to start off with that chapter. And the book does a nice job of the whole history and early reforms and all these different issues. Now, but then it gets into the really legal standards. What happens in a case where there is domestic violence? Usually, if somebody is the victim of domestic violence, you can be a man or a woman. This is a equitable and egalitarian statute, but statistically, it's usually a woman seeking a restraining order. And why did they seek them? Well, they're the subject of domestic violence, but they have to meet a certain set of elements in order to be eligible to seek a protective order. What's a protective order? You're basically saying, I'm in fear of this other person and I feel I need some kind of protection, and I look to my government to give me that protection. And a lot of people say, well, it's ultimately going to be just a piece of paper. But there, I think, at least anecdotally, there's some evidence that a person who served a piece of paper saying, do not abuse or do not contact Jane Doe might chill the situation somewhat and keep that person away from the petitioner or the plaintiff, and that might create a distance, if you will, and hopefully a lack of violence, because when these two people get together, it's a powder keg. And so I think there's some evidence it works, and society is trying to deal with how do we prevent further domestic violence, and this is the tool we have, and I know it's limited. And that's one of the things I'm going to put in the discussion board about whether it's effective and what are the pitfalls of it, and whether or not it's subject to abuse. But let's just go through the standards. So first, you have to be in the right relationship to even seek a restraining order. Say if I was working at the Mount and a coworker was threatening me in some fashion, could I go seek what we call in Massachusetts as a Chapter 209A restraining order to seek an order keeping them away from me or not abusing me or paying me damages? No, I can't, because it has to meet a certain standard of a relationship. Massachusetts defines it as a household member. And I'll put the statute up there, and a lot of students get intimidated when they read that statute because I put it up there with all the annotations and footnotes and edits, and that becomes very, very intimidating. But I put it up there anyway so you can look at it. You're certainly welcome to do a little research on your own in terms of what the elements are. But first you have to be called it's called a household member, but then they define it in the statute. It's one of the statutes actually has a definition section, which I really like. So what's a household member? Anybody that lives in the same housing unit is eligible on that first element to get a restraining order. So if you live together with somebody, it could just be a roommate situation, and then you meet the other elements, you might be able to seek a restraining order. But it goes obviously beyond that. Anybody that's had a child together, they are eligible to get a restraining order upon one another if they meet the rest of the elements. So child together, living together. And now I'm not going to get into the very nitty gritty of what does it mean to be living together, because I have had some cases and there's some controversy and there's case law on it. If you really want to get deep into it, we can always discuss it later. But what if you live in a 3-decker and the guy lives down in the first floor of his own independent apartment on this 3-decker, and you live in the 3rd floor, or a client lives on the 3rd floor? Are they considered living in the same household? And the case law suggests no, probably not. But it depends on how much there's a common area and where these events are occurring. But I think you get the gist. One is you have to be a household member as one option, or not and, or you had a child together with the other individual. And that relates to the next one. Or then now the next one's not related to it. It's being related by blood or marriage. So you can get one against anybody in your family, my children, my spouse, my brother, my sister, my parents. All of those people meet the eligibility requirements. So household member is you live together, you have a child together, you're related by blood or marriage, called basically consanguinity or affinity, if you like fancy terms. The next one marriage obviously is huge, because sometimes marital relationships break down because of acts of violence or threats of violence. Abuse is what we call it. And then the biggest one, the one that's debated about quite a bit, and the ones that I've had a lot of involvement with in terms of litigation, is you had to be in if you don't meet those other standards, a substantive dating relationship. What do I mean by substantive? Especially in today's modern way in which people, I guess court is kind of a weird word, they begin a sort of relationship with somebody. Sometimes they do it online for a long time. They might not even physically meet for a long period of time. And so the court does an analysis. It's how long the parties have known each other, the nature of their interaction with each other. Is it just been over, I don't know what they're called, chat boards or apps on social media, or have they physically been present with one another? And what was the nature of their relationship when they got together? Is it just a platonic friendship, or was it of a romantic interest? And there's a whole analysis on what that actually means. So it has to be substantive. And I often ask an essay question about a couple who may have not really met and are kind of on a first kind of, look and see kind of a bowling event with friends, and then at the end of the night, some things go bad, and the question is they eligible for a restraining order? And the argument is they might or might not meet that first element of being in a substantive dating relationship. They don't live together. They don't have a child together. They're not married. They're not related by blood or marriage. And so the question is that a substantive dating relationship? You can see how the court has to really wrestle with that. Is there enough there to make the connection? Because we don't want people, I think society has done a balancing act here to not have domestic, that's what it's called, domestic protective orders, to be used when there's not the appropriate relationship. Otherwise, people can just say, hey, this person I work with, or this student who's in my class with me, they are meeting the other elements. I should be able to get a protective restraining order against me. And the court says, no, these are of limited jurisdiction, because it affects the defendant's civil liberties on some fashion if the order is going to be made against them. So that's the first set of analysis. You have to determine whether or not you're in that appropriate relationship. So if you are, what's the second tier? It is probably in some ways just as important as the first one, and more important in some ways. You have to be suffering from abuse. Now, a lot of people think this is criminal behavior, meaning you have to be having been physically attacked by another person. No, it doesn't necessarily arise to criminality, although it comes very close, because it's anything that puts the victim or the petitioner in a position where they feel they're in imminent fear of physical harm, even if they've never even been physically harmed. So threats of violence can be enough. Posturing in such a way to make the plaintiff feel overtly and objectively at risk of harm by the defendant's conduct is basically the standard. And it has to be imminent, meaning it can't be like veiled sort of threats that were old, like from a year ago, and you started thinking about it, and now you're going to get it. And that's one of the issues the court has to deal with. How fresh are these threats of violence or acts of violence? When did they occur? What were they triggered by? Motive behind them? All those things get explored in the court. And so those are the big two-tiered sort of elements to a valid restraining order. Is one, you have to be the correct relationship, household member, which is very expansive. It goes all the way to dating relationships and all the other blood and affinity or living together. Or it doesn't have to be and. And then you have to be suffering from abuse. And there needs to be a need. It's kind of a third element. It needs to be a need that you need protection from that defendant in order to make you feel safe and be able to function in society. These are huge. If you go to district court or family law court, either one of them, they both have what we call concurrent jurisdiction. Those of you who take my business law class always get kind of disturbed by all these jurisdictional questions, but a person can seek a restraining order in the district court, the superior court, the family court, the juvenile court. We basically open up all the courts because we want the victim of domestic violence to be able to have access to get these protective orders. In fact, at night, they can get them over the phone with an on-call judge temporarily. So I do a lot of district court work. I used to do a lot of family law stuff too. And back in the day, sometimes there'd be a pending divorce, but the litigants would take out or try to take out a restraining order in the district court. And oftentimes the district court would say, there's a pending case over in the family court, you really should take this restraining order action into the probate and family court where the pending divorce is occurring, or paternity cases, because it's all part of the same issues will be dealt with, and they overlap greatly. That's why it's in this family law text. It's big on family law. But sometimes the parties start off right in district court. And what do? This is the process. It's a bit complicated, but when you go through it, there's some rationality behind it. Somebody believes they're being abused by somebody in one of those relationship forms of a household member. What can they do to seek protection? And protection, again, is only a piece of paper ordering the defendant to do certain things. We'll talk about what you can seek under restraining order momentarily. So they go to the court, the appropriate court. And again, most courts in Massachusetts, not all, but almost all courts in Massachusetts have jurisdiction to hear the request for domestic relations relation order. And if it's after hours, on the weekend at night, and the court's not open, believe it or not, there's these emergency on-call judges that can issue a temporary restraining order until the court does open and a further hearing can be held. Here's the phenomenon, or the thing that sometimes troubles me, is if I'm representing, and I did just recently represent a young woman as a friend, in front of the family, and she wanted a restraining order against her ex-boyfriend who was threatening her, allegedly, and we went in to get a restraining order. Guess who doesn't get notified on the initial request to get a restraining order? The defendant. Is that fundamentally fair? Well, I'm a big due process person. I think it isn't all that fair on some level. Think about it. If someone's trying to get a restraining order at me, they could be in court tomorrow morning, and they could be seeking a restraining order, and I don't even know what's going on. It's called ex parte, and that will be on the test. What is an ex parte request for an order? Ex parte means without the other party being present or having any awareness that it's even occurring. And the reason why is the initial order is an emergency order. We don't want plaintiffs to say, oh my God, I'm so scared that my boyfriend or my husband or my wife or my kid or my uncle, they're going to kill me. I'm so afraid of them right now. If you had to go through the process and give them notice, it would take days potentially to make sure they got appropriate notice of the pending request for a restraining order. So the initial order is ex parte. So say it was me. I'm seeking a restraining order against my brother, family member. So I have that eligibility. I go there and he's been threatening me. He's beaten me up or something at a recent event. I'm very fearful. I go to court in the morning. He's not there. He doesn't even know what's happening. I fill out an affidavit, which is just a sworn statement. I outline the family relationship or the household member status. I claim or put in the affidavit why I've been subject of abuse, the nature of the abuse, when, how, and where, basic narrative. And then I put what I want for relief. Do I want him not to contact me? Do I want him to move out of the house that we live together in if we do? Do I want him to pay damages for property that he may have damaged in an assault on me? All these kinds of things can be requested. He's not even there. Judges tend to get these orders and they look through them and they question the plaintiff petitioner and ask them why they think they need an order, what's the nature of the relationship, and they go through it. But it's an entirely one-sided event. And I don't know about you, but if I was a judge, especially if it's a young lady seeking a restraining order against a boyfriend or a husband, and she's telling me horrific stories of violence and the other side's not there, I'm very likely to issue that restraining order. Because what's the level of proof you need? To get a restraining order, all you have to meet is the evidentiary standards by preponderance of the evidence. It's a very low standard, it's a civil standard. And so if the judge thinks it's likely or probable that the allegations you made are true, he or she must issue the restraining order on your behalf. And the other side hasn't had a chance to say their story, that this is all made up to get an advantage in child custody, or it's made up just because she met somebody new and wants to get me kicked out of the house, or she did this because I'm cheating on her and it has nothing to do with domestic violence at all, and she's doing it to screw up my life because I'm a cop, and if I get a restraining order against me, I'm going to have to be removed from the department because I can't have a firearm when there's an active restraining order against me. And that's that's the thing I'm going to put on the discussion board, is the question about whether these can be used immorally or unethically. And yeah, they can be. Most of the time, I don't think they are. But is there a significant minority of times where I do think people have used this as a tool of revenge or spite? Yeah, and I've been involved in a few of those cases. Hopefully not as the litigant trying to get them. But it does come across the spectrum quite from time to time. But if you spend time in district court, and if you're just going to go out and observe it, you can't right now with COVID, it's awful, or the probate and family court, you'll see the call of the list will actually sometimes take a break in some of the courts. Will say, at 9:45, we're going to do the restraining order calls. These are just the calls on the initial petition to get a restraining order. And then when you go, so they're done with those, they usually 6 or 7 of them in the Worcester District Court and all the different courtrooms. Then later, there'll be arraignments on the alleged violation of these orders. There's a whole area of expertise and practice that attorneys deal with, both on the civil end, the getting or defending of getting a restraining order, and then if there's an alleged violation, it turns into a criminal case. So this is a test question, the initial action of trying to seek a restraining order is a civil order. It doesn't have to necessarily involve criminality upon the defendant who it's being brought against. It's abusive, but it's not necessarily criminally abusive. But if that order is allowed by the judge, and then the defendant fails to abide by it, either abuses the plaintiff or contacts them if it's no contact order, refuses to move, does some other act that's inconsistent with the orders in the restraining order, they now violated a criminal law. So it's kind of a hybrid area of law where the initial and the longer term restraining order a defendant is all civil. And somebody's judge goes, it's only a civil case. Why is the defendant upset about them getting against it? We'll talk about that because it does impact your life significantly if you get a restraining order against you. So after that day, you go in and say, it's me. I go get a restraining order against my brother. I'm there. I make the petition on my own. I plead my case in front of the judge. There's no defense attorney or defendant challenging the truth of what I'm saying. And I have to admit, there's a lot of pressure on the judge, especially maybe not in my case, but, and I don't want to sound sexist, but if there's a 35-year-old woman with 3 little kids who's deathly afraid of her new boyfriend or her future ex-husband because he's been beating her and threatening to kill her, and that's all I hear, I'm gonna defer to protecting this person seeking the order. I don't want to be that judge that wakes up 2 days later and says, woman comes in seeking help from abusive boyfriend or husband, judge fails to give order, and woman's murdered in some, well, there's no good murder, is there? But it's usually some burned to death or something like that, some real, it kills all the kids and everything else, and then that judge is hung out to dry as being someone who didn't afford protection to someone who sought it. But that's not the law. Just because you seek protection doesn't mean you meet the standards. It has to be a household member, you have to be subject to abuse, and it has to be necessary to protect your interests and your physical person. And so you go in, the other side's not there, the judge may issue the order. And again, it's only on a probable cause standard or a preponderance of the evidence, a civil standard, very low. If the judge issues it, the defendant does have a right to be heard. It's called a 10-day date. And so within 10 days, the defendant will be served, usually by the local police department. Say someone got a restraining order against me, my ex-girlfriend gets a restraining order against me, my wife gets one against me. I'll be served at work or wherever I am, and I'll see what it tells me what I have to do. It'll say, in the meantime, I have to get out of the house. I have to not contact my former significant other. I have to maybe pay child support. All these different things can be gotten in the child support. In the domestic relations orders called Chapter 209A, and I'm again going to put that chapter up if you want to look at it. And what I'll have to do is I'll be given a 10-day date where I go back in court and defend it. So for 10 days, I might be really stewing, very upset, because maybe it is frivolous, maybe it is a lie, maybe it is really inconsistent with the statute in some way. But in that next 10 days, I will be receiving due process, meaning I will finally have my right to go into court with or without an attorney and say, this is complete nonsense. My ex-girlfriend, I haven't talked to her in 23 years. I did bump into her at a soccer game with our kids, and she met my new wife. I don't know. She went kind of nutty over that. I never even spoke to her. She was saying some things to my new wife. I don't know. Things were kind of weird. And that's it. And if the judge finds that credible, and what if then the plaintiff will be there too, and then the plaintiff said, judge might even question the plaintiff. Is that true? You haven't talked to this guy in 20 years? Oh yeah, that's true. But I saw him at the soccer game, and he had a smug look about him, and I thought that meant he was gonna, beat me up or something. And it turns out my ex-girlfriend turns out to be a little bit, not so stable, so to speak. Then the judge might dismiss it. I went through 10 days of hell, but that's the process in 10 days. It's now an adversarial hearing. It's not ex parte anymore. Both parties are invited there. Now, what if I didn't just show up and the plaintiff still did? Now the judge has the power to order it for a year. It could be a year order against me, and I'm going to tell you about what it can give the plaintiff in a second. After 1 year is up, the plaintiff can come back to court again and now seek a lifetime restraining order, a permanent one against the defendant. That was during my practice years. I've been practicing almost 30 years now. That changed. It used to have to be renewed every year. Now it's after the 1 year anniversary, the plaintiff has a right to ask for it to be a permanent order. Now, most people say that's good. These plaintiffs these victims of domestic violence should get these orders, but we want to make sure they're valid. And what can they get? So again, these household members related by blood or marriage in a substantive dating relationship or have a child together, those are the only ones. You can't get a restraining order against somebody else. You can get something else called a non-harassment order. I'll talk about that at the very end of the video. But now what can you get? Why is it so important for family law? Well, the biggest one in my opinion, not in terms of why we have the statute, but in terms of outcome, is if there's children involved between the plaintiff and the defendant, and the plaintiff prevails in getting a restraining order, they can get child custody, whether it's through the district court or the family court. And this is a test question. The family court can always amend when it comes to custody what the district court has done, because the family court is considered to have more expertise in relationships over custody and financial support for minor children. But either court can initially, on the granting of a restraining order, give the plaintiff, not the defendant, give the plaintiff custody of children that are between the parties, have to be between the parties. And I'll give you a quick story on that in a second. And pay child support, meaning the defendant has to pay child support to the plaintiff. It has to be the children between them. I've actually had this happen before. Plaintiff comes in, she's seeking a restraining order. She gets it on an initial 10-day date. I meet with the defendant. The defendant comes to my office, what's going on? And he tells me this is all nonsense. It's not true. It's because they're breaking up and she's doing it out of spite. And I said, well, she's trying to get the children. That's a bigger issue. And then all of a sudden the guy goes, I don't know how she can get my kids. He goes, what do you mean, her kids too, right? He goes, no, these are my kids. She's the stepmom. She has no parental rights to get those kids. She can get a restraining order against the defendant to stay away, no contact, but she's not going to get the kids that she's not the either biological parent of or the adopted parent of. And every so often those kinds of cases come up. It's quite unusual because that person may have been caring as a primary caretaker of her stepchildren for quite some time and thought just intuitively that she'd have rights to basically get custody. They do not. But say it's a traditional case. There's a man and a woman. The woman's seeking a restraining order. They have two children together. Could the plaintiff in that case, whether it's the husband or the wife, let's assume they're married, can they get custody orders through the domestic relations restraining order? Yes, they can. And think about it. Who's going to get custody? Obviously, the victim's going to get custody in most circumstances. And here's the thing that's the most significant. When we get into the divorce section of this course, when we get into the whole thing about custody, there's an overriding presumption that if someone's had temporary custody during the pendency of the case, in that custody relationship's functionally working, we don't want to disrupt that. We don't want to have kids herking, jerking back and forth between mom and dad. And so whoever gets custody temporarily on the restraining order is very likely to maintain that custody later. It's a sledgehammer. Think about it. If it's working, Jane's got custody of the kids during this restraining order period. 6 months later, we're trying to battle over custody in the probate and family court. Do you think they're going to disrupt it unless mom is doing a really bad job? No, they're going to keep it the same. So the power of the restraining order is a sledgehammer advantage in getting not only temporary custody of children, but also ultimately becoming a pattern by which the court doesn't want to disrupt. And here's the other issue related to restraining orders, but doesn't have to come up in a restraining order. If it's established that the defendant committed a significant act of physical abuse upon the plaintiff or a pattern of abuse against the plaintiff, there's a presumption that the defendant, should not get custody of minor children. That's a very powerful tool. Presumption can be rebutted because maybe you can come into court and show, but like any presumption, it's tough, right? Because the odds are against you. It's saying all things equal, this side wins, unless you can overcome it with countervailing evidence. It's already kind of like it's a slam dunk unless at the last second you can come up with a block. Very difficult. What would that block be? There are rare examples, but there are some examples where, okay, dad did a serious act of abuse against mom, or it was creating a pattern, a substantive pattern of abuse against mom, but he's actually the superior parent. For whatever reason, that toxicity between mom and dad doesn't necessarily stem to the children, and he's been the one doing all the primary caretaking of the children. He's been a great dad. He's been taking the kids to all the school related functions and things and the pediatrics, and he's been a loving, caring parent. He's just been a real jerk in terms of the relationship, and he's been physically and emotionally abusive to their spouse. Is that rare? Very, very rare. But the point is, that's why it's a presumption and not automatic. But you can see how difficult it is to overcome a presumption. So let's go through the things a plaintiff can ask for in a restraining order. The most common is stay away and do no contact. That's pretty harsh if you've been living together. Now you got to move. And usually what they do is they tell you, if you're the defendant, you can go with police escort, and it usually is a very limited window because police have limited resources. Go to a police officer for a period of time, usually no more than like 40 minutes or something, or 30 minutes, and grab your belongings while that other party's not there to oversee making sure nothing inappropriate occurred, either to the person or to that person's property. Got to vacate the home. You got to get your stuff out of there. And you can't say it. It could be even your home. I know it's going to shock people, but I don't want to spend 2 hours doing this video. But don't be afraid to ask me questions off, via email or text or something like that. It might be your home, meaning it might be my home that I'm being thrown out of because I'm the defendant. I'm the one that did the abusive behavior. Now, that can be changed later, but I'm just talking initially. You can be kicked out of your own home. So stay away, no contact. And no contact's big. You can't call them up and say, I'm real sorry. When I was drinking, I pushed you. It was the alcohol. And I'm going to work on it. I'm going to go to SMA meetings. You can't do that. You can't contact them. And guess what else you can't do? And this is where a lot of people get in trouble. Geez, my sister's real close with my wife, or my soon-to-be ex-wife. I'll have my sister, my sister, can you call her and just tell her, I feel really bad and I'm going to try to straighten out my act. That's a violation of restraining order because you've contacted through a third party. None of that. No letters. It doesn't matter what the goal or the nature of the contact was. It's still a contact. We can't do it. So that's a common one. Stay away, no contact. You don't have to ask for that. You can say, I don't want the person to stay away. Or I want them to stay away. I want them to get out of the house or the apartment that we're living in. But I don't mind if they contact me as long as it's not abusive. Because maybe you have kids together and you're going to make arrangements. Or you want the court literally to say, stay away, no contact, except contacting for the purposes of arranging child visitation. You can be very creative with these orders. But it also makes it ripe for crossing the line. Hey, hon, or not hon, hey, Jane, I'm going to come pick up the kids this Saturday. I'm going to take them overnight. We're going to go up to, Wells Beach and have a nice weekend up there. Okay, great. I'll be over on 10. How's things going? Boy, I really miss you. Now they just violated the order? Yeah, because that's going beyond the purposes of arranging for child custody and pickup. And I'm already almost at 30 minutes, and I haven't really gotten to there's so many issues related to these things. So they stay away, no contact, and it can be all kinds of parameters within that. Again, child custody can be temporarily given through a restraining order, but what do we know about temporary orders when it comes to child custody? They tend to turn into permanent orders unless it's not working. And that's a very high standard. I mean, the person's going to be falling apart as the custodial caretaker of the child before we want to disrupt a stable situation. No contact, stay away, surrender firearms. That's a big one. Big one if you're a cop. I've been involved in a case like that. Police officer and his wife got into a big brouhaha. I'm not quite sure what happened. Different stories from different people. Wife sought a restraining order. That night he had to surrender his weapons. And then at the 10-day date, the case got dismissed because the wife didn't want to have it go forward. But for 10 days, this officer had to be put on administrative leave and didn't get paid. And it was with pay. It was actually with pay. But ultimately received a dismissal of the case and got his gun back. And the court doesn't have the power to say, okay, it's automatic. That one's automatic under the statute. If there's an active restraining order, domestic relations restraining order, you have to surrender your guns and your FID permit to the local police department, or surrender the guns to someone who's duly licensed. That one you can't have any way. You can say, oh, geez, I'm a police officer. I'll stay away from her. I won't contact her, but can I please keep my right to carry? The court has no discretion that they can't do that. And those are the big ones. So stay away, no contact, vacate the home if you're living together. Stay away from their place of work, which relates to no contact. Sometimes you can give a specific one, 1,000 yards. I actually had a trial over one where my client was the defendant. He was walking down in Southbridge, Mass. on one side of the road, very wide roads down there. And the victim was sitting on a park bench right outside the library down in Southbridge. My client said he never saw her, but he did say he was in the area at the time. And it could have been true. She did see him, and she admitted to the police. Because no, he never waved at me. He never said anything to me. He was completely across the street. And I went down there when it was late at night one time with a couple other people, and I did a tape measure. And it was 100-foot order. Stay 100 feet away from her, and I got it. It was like at least 400 feet away from where they. And she admitted, she was at one point, another point, and during the course of the trial, I had brought in a certain person who's a licensed certified engineer to talk about the distance between the 2 points, and he said it was at least 100 feet. I got a directed verdict because the defendant said, the victim said, that could be true. The nature of where we're standing was about correct, and what this other person, this expert supposedly was testifying, was valid. But anyways, you can have it specific like that. I've never seen one a mile, but I've seen 1,000 yards. No contact of any kind. Stay away from place of employment. That brings up a lot of really difficult cases, because sometimes if I'm representing the defendant, I'll say, whoa, judge, let's take this one with caution. They both, neither of them have any kind of criminal record, no past history of abuse. Whether or not this is true, you've obviously believed it is on a preponderance of the evidence. But if you deny my client the ability to go to her place of employment, he's going to lose his job. He works there too. And depending on the nature of the company, they might be able to pretty much stay away from each other. If it's a big, I'm trying to think of a big company. Simplex Grinnell. I've never been there, but I assume it's a fairly big company. She works in accounting and he works somewhere on the floor manufacturing product. Could they pretty much stay away? Yeah, no contact, no communication, stay away best you can, stay in your work order. Judges will try to be thoughtful. And they'll ask the plaintiff too, ma'am, are you comfortable with him working in his area of the office? And we'll say, yeah, I just don't want him talking to me. I want him to stay away. That's no problem. But can you see how the court's caught in a bind sometimes on these very difficult cases? And again, the initial 10-day order, ex parte, defendant doesn't even know about it. At the 10-day date, you have a hearing, both sides hash it out. And if the judge doesn't believe they met their burden by preponderance of evidence, the case is dismissed. If they do believe they met their burden, then all these different kinds of things, to stay away, no contact, move out, custody of kids temporarily, child support. And if they're married, there's even marital support. Arguably, the court doesn't usually like to get into that. If they're married, they want them to go to the probate and family court to resolve that aspect of it. But you can even charge money. You can have monies paid for changing of locks. It's really amazing, the length of things. And I don't know if I have a link, but the one in your book is a perfect example. It's from another state, but they're pretty much uniform in terms of all the different things you can ask for in a domestic relations order. These are narrow, though, in a big picture. And I've had clients coming to us. There's this guy at work. He's creepy. He kind of meets me at my car at lunch, and he goes, I always go to Panera's. He's always there. He's writing me little notes. They're not threatening, but, what if they were threatening? Can you get a restraining order against them? No. You don't live together. You've never been in a substantive dating relationship. You don't have a child together. You're not related by blood or marriage. But the guy's creeping out. Now he's starting to send you threatening letters. What can you do? We can have him charged with a crime, threat to commit a crime. And in that criminal action, you can say, if they get arraigned, you can say, all I want is if he gets released today pending the case, that he's to have no contact. Well, that's one way to remedy this kind of behavior. The other, there's a statute in Massachusetts that got expanded 10, 15 years ago. It's called a criminal harassment order. Chapter 258, Section E. I'm not that smart. I just looked it up before I started the video. Under Chapter 258, Section E, if the defendants acted in 3 at least 3 events in a malicious, non-meaningful method, there's not any rational reason why they're doing what they're doing, and it's putting the defendant or the plaintiff in reasonable apprehension for fear of their safety, then you can get what's called a harassment order. It's really expanded domestic relations types of 209As, which is the heart and soul of what we want to study in this class. But I do want you to know, if a person's behaving really poorly to another party, but they're not a household member under the statutory definition, there still is a remedy potentially under the 258E criminal harassment protective order. It doesn't always require criminal behavior. It just has to be at least 3 events of malicious behavior designed to harass the victim, and that alone. They may be open to abuse. And that brings up the next question. These are very, very powerful tools, and I'm going to put it up on the discussion board. They're often used to get advantage. Sometimes you go to an aggressive probate and family court attorney, an unethical one, and they'll say, you know what, boy, I really want my husband out of the house. He's a real jerk, and we're fighting all the time, and he's going to want the kids, and I want the kids. And a real unethical attorney says, well, has he been, not unethical, but I would even ask, has there been any domestic violence of any kind? Oh, no, nothing like that. I said, well, if he's pushed you or shoved you or threatened you, I can get a restraining order. I can get him kicked out this afternoon, and I can get you custody. And you can say, well, if I say, yeah, let's go down. Let's go get a restraining order right now. Can it happen? Does it happen? It does. It doesn't happen as frequently as one might imagine, but it can be abused. And that's why we want good judges to copiously ask questions to make sure it's genuine, to make sure it's fresh, that this really did happen and it happened recently, and that the victim is truly a victim and truly is in imminent fear of their physical well-being or their kids. You can get one on behalf of a child, by the way, too. I know this has been very scattered all over the place. The book is fantastic, if not too long. It's very copious, it's very detailed. But don't be afraid to ask questions or anything like that. I've done a ton of restraining orders, both helping people get them, defending against getting them, but then the next tier, which you do need to know about. If there is a valid restraining order against the defendant and the defendant violates it, it's now a criminal case. Now the government gets involved, and the government has to prove beyond a reasonable doubt that there was a valid restraining order and a defendant somehow breached it, broached it, did something that was impermissible under the restraining order. It's anywhere up to 2.5 years in the House of Correction. Very serious punishments can result. Now, obviously, if it's a phone call saying, hey, I'm sorry, I've been a real jerk. I'm going to try to straighten out my life. I'm going to go to some AA meetings. I'm going to try to clean up my act because it's mostly fueled by alcohol. Does that person deserve 2.5 years in the House of Correction if they've never done any other criminal behavior in life? Probably not. But what if the person does have a lengthy history of domestic violence and domestic abuse, and they're not just calling the person to apologize, but they're coming by in the middle of the night and trying to, bang on the window and being threatening, or they confronted their spouse at some event and pushed them down to the ground. Now there's an assault and battery, but on top of that, there's a violation of the restraining order. Could there be a fairly lengthy jail sentence as a result? Yeah. But what's the difference? It's now a criminal matter, and the difference is it's proof beyond a reasonable doubt, and now you have a right to a jury trial. At the initial inception of getting a restraining order, it's just in front of a judge. No jury's involved whatsoever. Kind of been all over the place in this little outline, but hopefully you get some meaning out of it. I do a lot of these kinds of cases. It's really amazing if we ever get a chance. Those of you that are really, I know some of you are paralegal majors and law majors, want to be lawyers or paralegals. I really urge you to sit in the district court or the probate and family court. I don't know if the probate and family court does it, but at one time they'll have like a whole section just on restraining orders. You can watch them both on the alleged violations or extensions, renewals, or application. And it just takes up a huge part of the court's time, restraining orders, because domestic violence is rampant, and it's sad. And if I've suggested that it's not legitimate, I don't mean to at all. I just know, like anything that has legitimacy, people can use it as a tool illegitimately as well. And I think of people who are really trying to gain advantage in a system, especially when it comes to custody of children or possession of a marital home. It can be used as a very, very powerful tool illegitimately. But hey, share your thoughts, share your ideas, and I'll hopefully have a new assignment up on the Blackboard right now, along with a new discussion board question. Be well.